All right, good evening, ladies and gentlemen of the media, and welcome to this emergency press briefing. In the last few minutes, many of you in the media have reached out to me seeking to inquire about what government makes of the press engagement that Her Ladyship, the Chief Justice, just had, which bordered on the petitions brought against her and the deliberations of the committee tasked to look into the matter. Ordinarily, if the matters were left to the content of the petition and the processes being undertaken by the committee, we will not have cause to comment because those are matters beyond the purview of the president or the government. But a number of things were said at the media engagement that, if left uncorrected, could create an erroneous impression and project government in a very unfair, unjust, unwarranted light. To begin with, we respect the right of Her Ladyship, the Chief Justice, to express any view that she holds about the matter in question, to the extent that it is consistent with the rules, because the Constitution makes it clear what the processes are in determining a matter of the sort that we are engaged with. The Constitution requires confidentiality on the part of all parties. It is the reason why the presidency, on behalf of His Excellency the President, has refrained from commentary on the matter beyond stating what the President has done in compliance with the Constitution. So it would have been desirable that that constitutional provision was respected by Her Ladyship, the Chief Justice, so that we do not have to engage in public commentary up until the time that the committee looking into the matter makes their determination. We are compelled, however, to correct certain misimpressions that were created at the briefing. To begin with, let me point out that as yet, nobody has been able to ascribe any known verifiable constitutional breach to the president in the way that he has handled this particular matter. From the very first steps in this matter, the president has kept fidelity to the Constitution and has respected the spirit and letter of the Constitution. Everything he has done has been by the book. That is why all those who have commented on the matter, including Her Ladyship, the Chief Justice, have been unable to point to any specific provision under Article 146 that the president has been in breach of. Second, in terms of confidentiality, the president has acted strictly in accordance with the Constitution. At no point in time has the presidency put out anything in any way, shape, or form that remotely resembles any of the contents of the petition. And the only communication that has gone out on this matter have been about the steps that the president has taken in accordance with the 1992 Constitution, Article 146 to be precise. 3, Her Ladyship, the Chief Justice, all but insinuated that there was some political agenda at play to oust her, and that this whole process is a result of same. Let me place on record, without fear of contradiction, and let me be clear that no such political agenda exists. His Excellency the President took an oath to which he was incidentally sworn by Her Ladyship, the Chief Justice herself. And in that oath, he swore to abide by the 1992 Constitution. He is enjoined to act a particular way when he receives petitions of the sort that he has received. And that is all that His Excellency has done. he has had no choice in the matter. The president cannot say that he has a view about how things should be done, and therefore, if petitions have come, he will fail to act. If he did that, he himself would be in breach of the Constitution, and therefore, he has been enjoined to act as any responsible leader or president of the Republic of Ghana would be required to do, as stipulated by the 1992 Constitution. The fourth point is also that we cannot have a sacred cow mentality in the way that we handle state affairs. Every single public official, from the president to the speaker, to the chief justice, to Supreme Court judges, to ministers, to all public office holders, are bound by the provisions of Ghanaian law. Indeed, it was the former Australian Prime Minister, Kevin Rudd, who once said that when you join the game, you play by the rules. So no public official is allowed to raise him or herself above the laws of Ghana. It does not matter how sensitive your position is. Once Ghanaian law dictates that certain processes be undertaken in respect of some alleged misconduct, the rules must come to play. And that is the only guiding principle that President Mahama has operated by in all of this. So any claim, any inference, any innuendo, any imputation of a political motive to the president in respect of these processes are unfounded, they are false, and cannot be allowed to stand. And I wish to place that on record. As yet, absolutely no evidence of same has been furnished in any way, shape, or form. And therefore, I am minded to strongly reject that effort. Unfortunately, Her Ladyship, the Chief Justice herself, has added to this commentary, which initially was the tone of elements of the opposition. And it is deeply regrettable that this should happen when the president has been above board and conducted himself in strict compliance with the Constitution of Ghana. The other point that I wish to also place on record is that the attempt to link the dastardly killings of some Supreme Court judges and a military officer to this case are most disingenuous. To begin with, this government and President Mahama have nothing to do with the killing of any judge. Second, there's absolutely no nexus between the petitions that have been brought and that unfortunate incident in our past. So any effort to link the two is regrettable and should not find space in this sort of discourse. It is most undesirable, it is most unacceptable. Now, the venue in question is the Edu Lodge. Yes, it is close to the Osu Castle, which used to be the former seat of government. As I speak, there are government agencies that operate there. So it is a public place. The Osu Castle is a public place. You can go there to conduct official government business. Beside it are private residences owned by Ghanaians who move freely in and out of their residence, even though they are situated very close to the Osu Castle. So the impression that a facility in the vicinity of the Osu Castle necessarily makes it intimidating or foreboding is completely misplaced. It is unfair. It is not justifiable. Now, Edu Lodge is a state facility which is often used to house high-ranking officials who visit the Republic of Ghana. It belongs to the state. The decision to use that place was not that of government or President Mahama. The committee requested that they needed facilities of a certain status that could house their activities and that could facilitate a smooth running of the proceedings. And that facility was available. It is equipped with modern amenities that will facilitate the work of the committee. And the state only offered it upon the request of the committee. let me also state that that facility is not intimidating. It is like any regular state facility where business can be conducted to the extent that it is put in the right shape. Wherever these proceedings were held, it will still be in camera, as clearly stipulated in Article 1468 of the 1992 Constitution. So that the proceedings are being held in camera is only in compliance with the Constitution. So it doesn't matter where it is held. And any security measure put in place is only intended to secure the place so that persons who are not authorized to be part of the proceedings do not come there and create any inconvenience. I believe that even if the hearings were held at the court premises, it will still be under significant security controls to ensure that only authorized persons have access to the place. So to describe Edu Lodge in the terms that Her Ladyship, the Chief Justice, did was most unfair and unjustifiable. It seeks to obscure the process and bring in unrelated matters that seek to cast some aspersion or ill motives on government for affording the committee a place to do its work. As I indicated, we have no interest in violating the Constitution by going into the merits of the case. And that is why government has refrained. Let me put it on record that government itself has had cause, indeed the president himself had cause, to lament the way in which some correspondence around this matter got into the media. You will recall that the very first sign of any leakage was the letter that the Chief Justice wrote requesting for copies of the petition. Before the letter got to the presidency, it was in the media. And you recall that in the president's response, in which he also took the opportunity to forward the petition to her, we raised that issue, that it was not acceptable. Indeed, we had cause, the president had cause then to ask his executive secretary to mark the documents that were being sent to the Chief Justice in order to guard against any leakage. So at no point has anybody leaked anything. Also, it must be noted that even the media houses that first broadcast the content of these petitions were media houses that you can say are aligned to the opposition. And they are the ones who have gone to town with this sort of thing. So to attempt to cast aspersions on the presidency is most unfortunate, and it causes what should be a smooth process leading to the determination of the merit or otherwise of the petitions that have been brought. So in summary, I would say that what has happened today is most regrettable. And as government, or as the president, President Mahama is committed to upholding the rule of law. We cannot have a situation where, depending on who is involved, the Constitution is set aside. All Ghanaians are equal before the law, in the same way that our courts have dealt with individuals in accordance to law. If members of the judiciary themselves are alleged to be engaged in some wrongdoing, the processes laid down and spelled out by the Constitution ought to be respected. And that is exactly what has happened.